Well, good morning, everyone. My name is Jeffrey Salant. I am the HOA Information Officer for the Division of Real Estate, which is a division of the Colorado Department of Regulatory Agencies, also known as DORA. This morning, we are going to talk about following and enforcing CC&Rs. Specifically, what are CC&Rs? Why are they so important? How is notice provided that CC&Rs exist? We will talk a little bit about a traditional real estate transaction involving an HOA. We'll discuss the distinction between the declaration and the rules and regulations of an association. We'll provide some information on what you can do to ensure that you are familiar with your association's CC&Rs. And as a board member or a community association manager, what are some best practices when enforcing them? There are 3 handouts attached to this webinar: a PDF copy of this presentation, a copy of the Colorado Common Interest Ownership Act, also known by its initials CCIOA or Kiowa, and a copy of the Colorado Nonprofit Act. You may download them at any time by clicking on the blue links located under the Handouts tab on the GoToWebinar control panel. Finally, please note that today's presentation will be recorded and uploaded to the division's YouTube channel, and it should be accessible within 24 hours. The web address for the division's YouTube channel is youtube.com/c/Dora Division Real Estate, all one word and no of. This web address will also be listed on the final slide of today's presentation, and you should also receive a follow-up email within 24 hours of today's presentation containing a link to the division's YouTube channel. Please note, the information provided during today's presentation is for educational purposes only and is not meant to provide or be construed as legal advice. Any legal questions should be directed to your attorney. Before we get into the presentation topics, I want to take a moment to talk to you about my office, the HOA Information and Resource Center. The HOA office is a statutorily created office, and my position, the HOA Information Officer, is appointed by the Director of the Division of Real Estate. Per statute, the HOA office provides information to homeowners regarding their basic rights and responsibilities under Kiowa. We gather, analyze, and report information through complaints and HOA registrations, and then we write an annual report to the legislature. We create resource materials, provide educational opportunities, and we present HOA forums such as this one. We also maintain a website with information for the public. And finally, we administer the registration program for HOAs. As for what my office does not do, the HOA office is not a regulatory program. We do not mediate or arbitrate. We cannot provide legal advice. We do not act as an advocate. We cannot assess fines or penalties, and we do not enforce an HOA's failure to register. Since we are going to be talking about enforcement today, I think it's important to review some basic information about HOAs in Colorado and the current lack of regulatory oversight. As mentioned, in Colorado, HOAs, or common interest communities, are governed by the Colorado Common Interest Ownership Act, or Kiowa. This law defines the rights of unit owners, as well as those bestowed upon the association. It also defines the responsibility of an association as directed by its executive board. Kiowa provides for the enforcement of those rights and responsibilities through civil litigation. Unfortunately, the state has no authority to intervene in any association member's conflict with their association, nor does it have any jurisdiction to enforce the rights and responsibilities defined in Kiowa or an association's governing documents. Succinctly speaking, there's no regulatory oversight of HOAs or community association managers in the state of Colorado. Any dispute between a homeowner or homeowners and an HOA is considered a civil matter. This information is important specifically today because we will be speaking about enforceability, and at times I may reference a situation where enforcement of a certain rule or regulation may be improper due to the manner in which the rule or regulation was created, or that the manner in which it is being enforced does not comply with established law. So if you find yourself in such a situation, while you may always present evidence of non-compliance directly to your association, and I encourage you to, if they are unwilling to come to a satisfactory resolution, you will have to involve the courts in order to have any violation issued by your association deemed invalid. Okay, so what are CC&Rs? Well, the initials stand for covenants, conditions, and restrictions. In understanding why they're so important, it may help to first look at a few definitions. So Kiowa defines an HOA, again, also known as a common interest community, as meaning real estate described in a declaration with respect to which a person, by virtue of such person's ownership of a unit, is obligated to pay for real estate taxes, insurance premiums, maintenance, or improvement of other real estate described in a declaration. And this leads us to our next relevant definition. What is a declaration? Kiowa defines a declaration as any recorded instruments, however denominated, that create a common interest community, including any amendments to those instruments, and also included, but not limiting to, plats and maps. Although the term map may seem like an easily definable term, in the context of common interest communities, map is defined as meaning that part of a declaration that depicts all or any portion of a common interest community in 3 dimensions, is executed by a person that is authorized by this title to execute a declaration relating to the common interest community, and is recorded in the real estate records in every county in which any portion of the common interest community is located. When we read these definitions together, we can see how recording an association's declaration, including maps in every county in which any portion of the association is located, is intended to put potential purchasers of property within that association on notice that such an association and CC&Rs exist. While you may be thinking to yourself that this is an inefficient means of providing effective notice, recording instruments as a method of notice is actually codified in statute in the state of Colorado. One of the most important parts of buying real estate is the time that is taken by the buyer to do their due diligence. This includes reviewing all recorded documents associated with the property to determine any encumbrances, such as CC&Rs. Additionally, the Colorado Real Estate Commission approved contract to buy and sell real estate is also an effective way of providing notice of the existence of a common interest community. So this is Section 7 of the Colorado Real Estate Commission's Residential Contract to Buy and Sell Real Estate, also known as the CBS. You may find it on the division's website at dre.colorado.gov under Real Estate Contracts and Forms on the Real Estate Broker Program page. So despite the fact that it contains bold, capitalized letters, it is likely the most ignored section of the CBS. Discussion of whether or not a property is located in an HOA typically does not occur between a potential buyer and their broker until after the viewing of a property has taken place, discussion of price has occurred, and the potential purchaser has become vested in the idea that this may be their new home. At that point, it is much more difficult for a potential buyer to comprehend the significance of the power and authority an HOA will have over their home and what they may do with it. Section 7.2 of the CBS obligates the seller to provide the purchaser with the association documents. Section 7.3 of the CBS defines association documents as meaning all of the association's governing documents, all minutes of the annual owners meeting, as well as minutes from any executive or managers meetings, a list of all association insurance policies, and a list by unit type of the association's assessments, including both regular and special assessments, as of the most recent annual disclosure. Section 7.3 goes on to also define association documents to include the association's most recent financial documents. It further clarifies that the financials must contain the association's operating budget for the current fiscal year, the association's most recent annual financial statements, the results of the association's most recently available financial audit or review, a list of the fees and charges that the association's community association manager or association will charge in the connection with the closing of a property within the association, including but not limited to any fee that is incident to the issuance of the association's statement of assessments, which is also known as a status letter, a list of all assessments required to be paid in advance, any reserves or working capital due at closing, and the results of any reserve study if such a study has been conducted. So despite that long list of documents that are required to be provided to the buyer of a property in an HOA, one of the most frequent allegations we hear is the allegation that the existence of an association was either not disclosed to a potential buyer or the existence was minimalized. For example, the HOA is just a road association, or they can only tell you what color to paint your house. When you sell real estate located in an HOA, you have a duty as the seller to provide all of the documents listed in Section 7 of the CBS. For any brokers who may be in attendance today, please don't misunderstand. You are in no way obligated to, nor should you attempt to, explain any association document to your clients. However, strongly encouraging your clients to review the association documents and suggesting that they contact a licensed attorney to clarify any right or responsibility that they do not understand is an absolute minimum duty. If you strive to provide the absolute best service to your buyer clients, you should consider taking the extra steps of guiding them to the HOA Information and Resource Center's website, which does have extensive information for potential purchasers of property within an association. For seller's agents, ask your clients to request their association documents as soon as the listing agreement is signed. If a sale isn't consummated before the next association meeting, updated documents may need to be requested. Since there are additional sources of authority which govern HOAs, it's helpful to have an understanding of where CC&Rs fall in the hierarchy of authority of documents used to govern HOAs. Here you can see that the federal constitution and federal statutes are the supreme law of the land, while the rules and regulations fall at the bottom of the hierarchy. CC&Rs fall squarely in the middle of the sources of authority, just above articles of incorporation and just below the map or plat for the subdivision or association. When we hear from homeowners who tell us they've received a violation notice, they're usually speaking about an alleged violation of the association's rules and/or regulations. The way that CC&Rs are intended to be used by an association requires the declaration contain broad protective standards and restrictions for the community, for which the rules, regulations, and policies are intended to explain, clarify, and define in greater detail. Here you can see that in addition to providing protective standards and restrictions, the declaration is also used to declare ownership of certain common elements, establish maintenance responsibilities, set forth goals of the association, and to address the process of transition of the community from developer to owner control, whereas the rules, regulations, and policies provide more detailed explanations, clarifications, and definitions of restrictions and authorities found in the declaration, bylaws, and articles of incorporation. They set forth a variety of procedures, including those used to put forth restrictions into effect, as well as those required by Section 38-33.3-209.5 of Kiowa regarding responsible governance policies. It may help to think of the declaration as the entire beach, whereas collectively the rules and regulations are individual grains of sand. As mentioned, Section 38-33.3-209.5 of Kiowa addresses responsible governance policies. It requires HOAs to adopt policies, procedures, rules, and regulations regarding specific issues, such as conflict of interest, dispute resolutions, and of most relevance, enforcement of covenants. Interestingly, the content of those required policies is not specified. Therefore, if a community does not want to engage in any type of voluntary pre-litigation alternative dispute resolution, such as mediation or arbitration, they may adopt a dispute resolution policy which states that. Excuse me. Okay. So many times a violation is due to unpaid assessments. One of the required responsible governance policies regards the collection of unpaid assessments. As a best practice, this policy should include items such as the due date of the assessment, as well as any date it is considered past due, late fees and interest that may be charged, and any payment plan options, keeping in mind that Kiowa requires that an association, upon request, make good faith efforts to coordinate a payment plan with the delinquent unit owner who has not already entered into a payment plan with the association. A collection of unpaid assessments policy should also include notice requirements and a description of the action required to cure a deficiency, keeping in mind that Kiowa requires an association to provide at least 30 days to cure a deficiency. So having covenants, conditions, and restrictions is really only beneficial if there's an effective way to enforce them. For most HOAs, monetary penalties are often the mechanism of choice. An association may enforce its rules through fining members, sending delinquent accounts to collections, placing a lien on the offending member's property, filing a civil lawsuit, and typically, as a last resort, foreclosing on the offending member's real estate. Of note is the requirement that an association must have a policy governing the imposition of fines, which must include a fair and impartial fact-finding process before they are allowed to levy a fine against a unit owner for a violation. Likewise, prior to the initiation of any action to collect on past due assessments and other delinquent payments, the association must first adopt and comply with a collections policy. Thereafter, the association must make that good faith effort we discussed regarding establishing a payment plan with a unit owner if they have not previously entered into one. I know that a lot of you heard the words fair and impartial fact-finding process, and your ears perked up a bit. So let's talk about that. Kiowa allows for this process to be an informal one, but it must, at minimum, guarantee the unit owner notice and an opportunity to be heard before an impartial decision maker. Kiowa defines impartial decision maker to mean a person or group of persons who have the authority to make a decision regarding the enforcement of an association's covenants, conditions, and restrictions, including its architectural requirements and other rules and regulations of the association, and do not have a direct personal or financial interest in the outcome. A decision maker should not be deemed to have a direct personal or financial interest in the outcome if the decision maker will not, as a result of the outcome, receive any greater benefit or detriment than will the general membership of the association. One of the most powerful tools available to HOAs in Colorado is the statutory lien. The statutory lien exists on any unit for any assessment levied against that unit or fines imposed against that unit. Interestingly, unless an association's declaration provides otherwise, Kiowa describes the term fines imposed to include fees, charges, late charges, attorney's fees, fines, and interest charged. The association has what's known as a super lien, meaning that it has priority over all other liens. Generally, liens have to be recorded in order to be perfected. However, in Colorado, the recording of an association's declaration constitutes record notice and perfection of the lien. The association need not take any further recordation of any claim of lien for assessments for the lien to be valid. And interestingly, an association has 6 years from the time the full amount of assessments becomes due to institute enforcement actions. A lien for unpaid assessments is extinguished unless proceedings to enforce the lien are instituted within such a time. Although the HOA Information and Resource Center, again, is not a regulatory program, Kiowa has mandated that in addition to being a clearinghouse of information, the center will administer the HOA registration program. This program, which is mandated by Section 38-33.3-401 of Kiowa, requires all associations to register with the Division of Real Estate and renew on an annual basis. Initial registration costs $30 and renewal costs $38. This flat fee is in contrast to other states, such as Nevada, who charge a per door fee. Fees are waived for associations with $5,000 or less in annual revenue. In addition to registering with the division, HOAs are generally organized as nonprofit corporations and therefore must also register with the Colorado Secretary of State. The most significant consequence to not registering as an HOA with the Division of Real Estate is the loss of the ability to impose or enforce a lien for assessments or to use any enforcement mechanism until the registration becomes valid. You may check the registration status of your HOA using the division's Search for a Licensee tool located on our website at re.colorado.gov. Once there, you can hover over the Online Services tab on the blue banner and select Search for a Licensee. Please note that the Division of Real Estate does not enforce the registration provision of Kiowa and is unable to answer any questions related to a homeowner's receipt of a violation during a period in which their HOA was unregistered. Those questions should be asked of a licensed Colorado Community Association attorney. Kiowa requires associations to annually disclose certain information within 90 days after the end of each fiscal year. This slide shows all the information required to be disclosed. It includes some nominal information, such as the name of the association and its manager, if any, as well as some more pertinent information, such as the association's annual financial statements, including any amounts held in reserve. Note that the association's bylaws, articles of incorporation, and rules and regulations are part of this required disclosure. Reviewing your association's annual disclosure will be the absolute best way to stay up to date with your association's governing documents. Kiowa also specifies the manner in which the disclosure must occur. It may be posted on the association's website with a notice of the website address being sent via first-class mail or email to its membership. It may be maintained as a literature book or binder at the association's principal place of business, or it may be disclosed through mail or personal delivery. Regularly attending meetings of the association is also another way to stay up to date with any changes to your governing documents. Kiowa states that regular membership meetings must be held at least once per year, while special meetings may be called by the president of the association, a majority of the executive board, or by a vote of 20% of unit owners or any lower percentage specified in the bylaws. Something that frequently surprises people is that Kiowa does not actually require notice be given of board meetings. However, your association documents likely do. Another good way to keep up to date with your governing documents is to do your best to keep your contact information with the association up to date. One of the more frequent complaints we hear is that notices from the association are going to the physical address of the unit within the association. However, many HOA members may not live on site, which means the unit in the association may not be the best mailing address for them. By keeping your contact information up to date, you are doing everything in your power to ensure that notices get to you. Another overlooked way to keep up to date with any changes to your association's CC&Rs is to get to know your board. Regular communication, even just quick emails to say hello or a letter to introduce yourself, can go a long way in making sure that you are well informed. In the course of these casual conversations and correspondence, you well may find that information is more readily available. Finally, a great way to keep up to date with the issues and concerns in your association is to volunteer whenever possible. This could range from nominating yourself for candidacy to the board, or volunteering for a committee, or just making yourself available to leadership for any volunteer tasks that they may need assistance with. Participating in your community's governance can expose you to the process of how things are done and how things get accomplished in your association, and it may very well help you to better understand those processes. As a board member or community association manager, it's important to regularly review the processes in place to enforce an association's covenants. Every few years, an association should review all of its policies, including its covenant enforcement policy. This policy, like many of the required responsible governance policies, is going to be unique to the individual community it governs. When evaluating if your association's policy is appropriate and effective, ask yourself some questions. What are the goals of the community? Many associations only exist to provide some nominal services, such as snow removal, road maintenance, and/or irrigation services. Once your community's goals are determined, ask if these goals require strict adherence to the covenants. Primarily service-oriented communities may be more focused on the provision of these services rather than strict adherence to aesthetic requirements, whereas a more upscale association with numerous community standards may need to take a more stern approach to covenant enforcement in order to meet its community's goals. Finally, what resources does your association have to enforce its covenants? Depending on the community, covenant enforcement may require substantial time and resources in order to be effective. All of these concerns should be considered when creating and reviewing covenant enforcement policies. Although Kiowa does not provide guidance on the substance of a covenant enforcement policy beyond the requirement that it include notice and hearing procedures, as well as any schedule of fines, there are certainly some best practices that we can discuss. Since Kiowa requires associations to provide a notice provision in any covenant enforcement policy, any initial notice of a violation should be in the form of a warning. The warning notice should describe with some reasonable particularity what the alleged violation is, how the homeowner may go about curing the violation, and a date within a reasonable amount of time in which the homeowner has to cure the violation. If the homeowner does not cure the violation within the allowed time frame, the association may then send a second notice to the homeowner. This notice should state the same information from the warning notice, but should also state that there is a fine associated with continued non-compliance. If the violation continues to persist, the association should hold a hearing on the matter with the homeowner, or without the homeowner if the homeowner fails to schedule a hearing or schedules one but fails to attend it. Once an opportunity to have a hearing on the matter has been provided and an impartial decision maker has decided the issue, a fine may then be assessed. As far as following CC&Rs, receiving a violation notice from your association can be a shocking and often anger-provoking circumstance. Avoid the urge to react emotionally. Read through the entire violation notice and take notes on anything that you have questions about or anything that you might like to present rebutting evidence of. Unfortunately, tenants in HOAs have substantially less rights to petition any violation received on their own. If you are a tenant in an HOA and you receive a violation notice, you should immediately contact your landlord and involve them. They will need to correspond with the association on your behalf and may need to act as an advocate if you want to contest the violation. Remember that you have a right to a hearing and that it is the most appropriate place to air your grievances. Trying to handle the matter outside of a hearing is not advised and many times will only frustrate the situation. If you believe that you have genuinely not violated any of the association rules, then you should request a hearing on the matter. While you are entitled to a hearing regardless of your culpability, keep in mind that simply disagreeing with the rule is not a good faith reason for requesting a hearing. The best place to discuss the efficacy of a community rule is during association meetings and work groups. If you do request a hearing, make sure that you attend it. The HOA Center frequently hears complaints from homeowners that they did indeed request a hearing, but for one reason or another were unable to attend, so the hearing was held without them and a fine was imposed. While this may seem unacceptable to many, it is generally acceptable under the circumstances. Do not compare yourself to your neighbors. This one is really important. Just because your neighbor has a certain fence or painted a certain color does not automatically mean that you are allowed to do so as well. Many HOAs have procedures in place to request what's known as a variance to certain rules. Many times, homeowners are unaware of a variance received by a neighbor and assume that their similar conduct would be acceptable. This is not the case. Any deviation from your community standards should be based off of written approval from your board. Finally, remember, there is no regulatory oversight of HOAs. So if you are dedicated to fighting a violation at all costs, keep in mind that those costs may inevitably